Did you hear Jonathan?
No.
No. I think I'll just come out here. Thank you. No. Oh my God.
Was working fine the other day.
Sort of. I mean, fine.
Am I counting 8? Okay, so I'm going to call it out here.
You're gonna go here.
Yeah. So I'll be on in a second.
So before you come out, let me just tell the folks that are on video to go onto the audio, to mute their video, audio, and go into calling on audio. So
Oh,
we can get
because otherwise it'll be,
that- we'll get
even
that.
with me out here?
Yeah, it doesn't have anything to do with you out here.
Yeah, because it's still there, the audio
Okay.
problem. Well, you still gotta come out here.
Yeah, but the guy did yesterday, how he put everybody in conference call. I thought that proved everybody a lot better than the normal. Oh, he had everybody call in though.
I think it's
No, he kept his list. I don't know how he did it, but he dropped it into a conference call.
Good morning, can I have your attention, please? Hello, folks, this is the clerk for Department 86. For those of you that are on a video link, if you are on a video link, it is strongly suggested that you mute your video audio and call in on your audio link so that you can be heard clearly in the courtroom. The system currently is not optimal and it causes a loop. For the benefit of the court reporter. There is a delay in the system, so please pause before speaking and wait for somebody else to finish. Thank you. The court will be out shortly.
Conference manager, please enter your conference ID followed by the pound key.
What?
Oh, and finally, folks, please be on mute until you have to speak. It's very disruptive for all the other speakers. Thank you.
Conference ID is currently unavailable. Please contact the system administrator. Please enter your conference ID followed by the pound key. I'm sorry, the conference ID event is currently unavailable. Please contact the host or system administrator. Please enter your conference ID by the pound key. I'm still
folks, I
unable.
need you to mute your phone.
Please
I need you to
contact
mute your phone.
I'll be disconnected.
Great.
No. Good morning. Let's start with number 2, AIDS Healthcare Foundation. Could I have parties state their appearances, starting with the petitioner?
Your Honor, this is Petitioner's counsel, but I'm not sure if you can hear me.
I can hear you.
This is Kathleen Unger for AIDS Healthcare Foundation, Petitioner.
Thank you very much.
Good morning. This is Christian Marsh for Respondent, City of Los Angeles.
Thank you very much.
Good morning. This is Ed Casey on behalf of the Real Party and Interest.
Thank you very much. Ms. Unger, what can you tell me about the administrative record?
The administrative record was certified. It's complete. We're ready to go.
Okay. Mr. Casey, any objection to setting trial?
No, Your Honor.
Mr. March, any objection to setting trial?
No, Your Honor.
Okay, how about March 3, 2021 at 9:30 a.m.?
That's fine, Your
This
Honor.
is Ed Casey. Fine with fine.
Mr. March?
That works, Your Honor. That's
Okay.
fine. Thank you.
March 3, 2021, 9:30 a.m. Opening brief due 60 calendar days in advance of the hearing. Set service and filing. The opposition briefs shall be served and filed 30 calendar days in advance of the hearing and 15 calendar days in advance of the hearing. The reply brief shall be filed and served. The administrative record to be lodged when the reply brief is filed. And I will ask you to prepare a joint appendix, please. Ms. Unger, can you give notice, please?
Your Honor, I can give notice. We were planning to stipulate to a briefing schedule and page limits. We'd like to confer after this trial setting conference and then file a stipulation for your approval and order.
Sure, that's fine with me. So if you aren't able to reach I know you will, but in case you are not able to reach an agreement about a briefing schedule, then just rely on the default 60-30-15 schedule. All right?
Yes, Your Honor.
Mr. Casey,
Well-
did you want to say something?
No, Your Honor. I just had a quick question. I have to ask it just because of a different case with a different attorney, and that is, I assume you want the trial briefs in double space, 28 lined, as opposed to single space?
Yeah. Wow. That would be tough.
Yes, I know. That's why I ask it. It hurt my eyes in this other case to read it.
Yeah, I guess you could bury it all in a footnote to get in that single spacing, but yeah. Remembering your
Thank you.
audience. Okay. Thank you. Thank you, Ms. Unger. Give notice.
Yes, I will. Thank you, Your Honor.
Thank you, Your Honor.
Bye-bye.
Thank you, Your Honor.
Bye-bye. Let me go to number 3 on today's calendar, Fix the City versus City of LA. Who do I have for petitioner, please? Do I have someone for respondent, City? Maybe no one can hear me. Let me pass number 3. Let me go to number 4, John Doe versus the Region. I think I see Mr. Hathaway. Mr. Hathaway, will you state your appearance, please?
Mark Hathaway for Petitioner.
Thank you very much, sir. And who's here for the Region?
Good morning, Your Honor. Sandra McDonough for Respondent Regent.
Thank you very much.
We have no objection to setting trial.
Thank you very much. Administrative record prepared.
Excuse me?
Hathaway, has the administrative record been certified?
It has not, Your Honor, but I have significant dealings with the regents on a number of matters, and they always come through and prepare a certified administrative record timely.
Okay. How about March 5, 2021?
I'll note, Your Honor, that on Monday we will be filing a demur and motion to strike, and I believe our hearing is in January, which is the first date we could get.
Okay, let's see what happens with the demur. Mr. Hathaway, I think to be safe, I ought to set it in April.
That would be fine, Your Honor.
Okay, how about April 16, 2021?
Okay.
That works for the Region?
That works. I mean, of course, Your Honor, we believe our demur will resolve the case, but we can use that date for now.
Okay, we'll use it for a backup.
Okay.
And Mr. Hathaway, does that work, April 16th for you?
Yes, you said April 1-6. Yes. Is that in the afternoon?
It's at 9:30 and it is on April 1-6. Sorry for the math.
Your Honor, I'll prepare a notice with the 60, 30, and 15-day requirements for briefing for that date.
Great, 60, 30, 15, briefing, calendar days, notice and filing. Mr. Hathaway to give notice. Thank you very much. Have a nice weekend, both of you.
Thank you. You too.
Thank you, Your Honor.
Let me go back to number 3. Do I have petitioner on the City versus City of LA? On the line, I see you. Is Petitioner present on fixed petition? Okay, I'm going to pass it again. Let me go to number 7. Palladian versus Becko Enterprises. Do I have anyone? The matter's been removed to federal court. I'll ask the clerk to set a date in 90 days. It's not remanded. Under the local rules. Go number 12. Petition is Department of Industrial Relations. I think I have 4 attorneys on the case. For Dr. Fishman. Thank you, appearance.
Good morning, Your Honor. Mona Niemet of the Law Office of Brisbane and Niemet on behalf of petitioners.
Thank you. Mr. Kapp?
Your Honor, I believe Mr. Kapp is maybe having some technical difficulties. I know that he had joined the video. I'm not sure if his audio is working.
Okay. Do I have a respondent?
Good morning, Your Honor. This is Anna Catherine Benedict on behalf of respondents.
Thank you very much. Anyone else?
This is Rosemary DiPietro Antonio on behalf of respondents.
Thank you very much. Mr. Kapp?
Your Honor, can you hear me?
Yes,
This is Mr. King.
Take your appearance. Mr. Kapp?
Yes.
You make your appearance. Issue.
Thank you, Your Honor.
Let me go to the estate of Michael Jackson. Let me have
Good morning, Your Honor. Gerald Cohen of Freeman and Smiley on behalf of the executor. Your Honor, I tried to go on the audio, but it's telling me that the PIN is not valid. So there is some interference. I hope you can hear me, but this is a bit challenging.
Good morning, Your Honor. Margaret Lodice on Guardian Ad Litem.
Good morning, Your Honor. Craig Peters on behalf of Paris Jackson. Good morning, Your Honor. Nick Hutchinson on. Good morning, Your Honor. This is Scott Malton on behalf of Catherine Jackson.
We know how to so when they talk, their voice comes out, loops back into the echo. Do we know why somebody's having trouble with their PIN? This happened the other day. They can't call it.
Your Honor, this is Margaret Lodice. I had to try the PIN twice, but it ultimately did work, so I don't know if Ms. Cohen wants to try that again.
Hey, Ms. Cohen, do you want to try that? I'll just wait for you.
I'll try again. I've tried several times. They even gave me another PIN, which doesn't work, but I will try again right now.
Okay, my PIN didn't work this morning either.
Good morning, Your Honor. This is Nick Hutchinson on behalf of Michael Jackson, Jr. I'm not sure if my appearance came through with the feedback.
It didn't, but I knew you were trying, so thank you, Mr. Hutchinson.
Of course, Your Honor. And Your Honor, similarly, this is Craig Peters for Paris Jackson. I'm not sure if mine made it on the record either when we had feedback, but good morning.
Good morning. Is there, so you're for Paris Jackson, Mr. Hutchinson is for Prince, but I think that might have a great case. Mr. Peters, are you representing blanket as well.
Your Honor, this is Scott Balls. I'm here on behalf of Catherine Jackson. I am having some difficulty hearing what's happening.
I can't quite hear you. I know you're here for Catherine Jackson.
Thank you.
I'm going to skip Jackson for just a moment.
And, Your Honor, this is Margaret Lodice, just so Your Honor is aware. I have a 10:30 hearing as well, so it's fine to pass it, but at some point I will need to get off the phone.
Sure. Thank you. We'll get it done.
Thank you.
And I think I see that my opposing counsel is on video. Looks like Andrew Grassel, although I'm not hearing him.
Great.
Good morning, Your Honor. If you can hear me, I'm trying to dial into the backup audio now.
I can hear you. Are you on the backup audio?
No, I'm on the regular.
Okay, I'll wait for you.
If you are the conference host, press 1.
We'll never give you feedback. Does Snorri know about this?
Please enter your PIN, followed by the pound key.
You mean I should capital? Sure, no, I appreciate that. The more we can get visibility on the problem, I appreciate that. The more likely we'll get up there. You're top notch, and you've been. This is untenable. Yeah, that's what I was writing your answer to, because I'm not planning on it.
Good morning, Your Honor. This is Andrew Grassel.
Hi there, thank you. Okay, and do I have plaintiff's attorney still?
Yes, you do. This is Mr. Covington. I hear you.
Okay. Thank you. Okay, you're both loud and clear. I issued a written tentative, and I'm assuming you both have the written tentative. Pardon me?
I have not, Your Honor. We looked online last night and didn't see any. Is it posted online?
Yeah, you know what? We apparently have a technical issue with that. So give me just a few minutes, and I will get that posted. I'll come back to you. I apologize.
Oh, no problem, Your Honor. So we should just look on the standard list for tentatives for this department.
There is one for you on that. There is one for United Homeowners on an attorney fees motion, and there is also a tentative of a fixed city on a motion. So I'm going to take a couple minutes to get this posted properly, and I'll be back in just a moment. We'll continue properly.
Your Honor, this is Mr. Covington. I'm not sure. I didn't hear most of that. I'm not sure if Mr. Grassel did. It was breaking up. Did you say that you would get back to us and we should look online for the tentative?
I did. Give me 5 minutes.
Oh, yes, of course. Thank you so much.
Stand by, folks. We're going to try another way to get audio. Stand by. Stand by, folks. We're going to try to recover our audio another way. Now tell me if you hear that. You heard me say it? You heard me say it? Okay. That's what I wanted to know. All right, well, it's about to get real crazy because I'm going to have to put it on speaker.
But I also heard you say now tell me if you hear that.
Stand by, folks. We're still working on getting the audio back. Bear with us.
Let me go back to Michael Jackson. Did you have any success?
Your Honor, this is Gerald Cohen. I did get on the audio, and hopefully you can hear me okay.
I can, and I have Ms. Lodice. Ms. Lodice?
Yes, I'm here, Your Honor.
Mr. Peters?
Your Honor, Mr. Peters is coming back. He's having a technical issue on his end. I don't know if it's related to the system or his phone.
Okay, that was Mr. Hutchinson, right?
Correct, Your Honor. I apologize.
No, that's fine. Who do I have for Catherine Jackson?
Yes, this is Scott Muldoon.
Thank you. Mr. Peters?
Your Honor, this is Nick Hutchinson. I can especially appear on his behalf. He's given me that authority.
Okay. Ms. Cohen, somebody just walked in a fifth supplement while we were dealing with the posting of the tentative.
Yes, Your Honor, we tried to submit it yesterday, and we were not able to. We did file the redacted version. It's a replacement of Mr. Modauber's declaration.
Okay, and where do we, from your perspective, where do we stand on the petition?
So I spent, and Mr. Hutchinson can speak to this, I spent a long time with Mr. Hutchinson going over the fee petition. We went over last night in particular Mr. Modauber's new declaration, which is actually substantively the same as his other. There was just a correction of the period of time that was covered. And we went over Mr. Weitzman's declaration, and I believe that Mr. Hutchinson doesn't have any issues, but I will let him speak to that.
Okay, Mr. Hutchinson.
Yes, Your Honor, this is Nick Hutchinson. Ms. Cohen's correct. We spent a long time on the phone yesterday. She was kind enough to entertain some of my silly questions and some of my not so silly questions. And we were able to walk through each of these declarations, the math behind them, and the substance of them. And she's correct in the representation that I don't have any issues with the fee petition as constituted at this point.
And since you're standing in for Mr. Peters, because I think we still don't have Mr. Peters, do you know what his position is on the fee petition?
His position, I believe, is the same, Your Honor. I think his assumption was that this would be carried over a week. But at this point, I'm comfortable in him adopting the same position that I'm taking.
Okay. And Ms. Levy, tell me where things are with Blanket, because he's now an adult, correct?
Yes, he's an adult, Your Honor, and I have not taken part in any of these negotiations because I view my term as ended. I'm only on the hearing today because I filed my final fee petition.
So, Mr. Hutchinson, do you know if Blanket has counsel?
Your Honor, this is Nick Hutchinson. At this point, I don't believe he does. I spoke to T.J. Jackson. I've spoken to him several times, but pre-pandemic, they were in the process of interviewing lawyers or a lawyer search. And I believe that that's frankly been interrupted with COVID-19. At this point, I do not believe he's represented.
Okay, and on behalf of Catherine Jackson, your position?
Yes, Your Honor. This is Scott Muldoon. We don't have any issues with the petition.
Okay. So, Ms. Cohen, what you're looking for me today, since everybody is in agreement, is for me to approve the fee petition. Is that correct?
That would be much appreciated, Your Honor.
Okay. Let me ask about Ms. Lodice's final fee petition. Mr. Hutchinson, do you wish to be heard on that?
No, Your Honor, no objection.
And on behalf of Mr. Peters, are you able to make a representation?
Same position, Your Honor. No objection.
Okay, and on behalf of Catherine Jackson, any objection to Ms. Lodice's fee petition?
No, Your Honor.
Thank you very much. And Ms. Cohen, I'm assuming you're going to ask me to find that the fees constitute a cost of the administration of the estate?
Yes, I was going to, and necessary and appropriate administration expense, and that Your Honor order required the executors to pay from the estate. And we have no objection to the fee petition.
Okay, so...
And Your Honor, this is Margaret Lodice. One other issue on the petition, I had put in a sort of a placeholder for the costs incurred with the filing, and just so Your Honor has that, that was $501.60.
Okay. So I'm going to grant Ms. Lodice's fee petition and finding that there are necessary and appropriate expenses of the administration of the estate. The administrators or personal reps are ordered to pay Ms. Lodice's final fee petition and costs in the amount of $501.60. The court will grant the motion to seal, and the court will...
Your Honor, I'm sorry. The $501.60 is just the cost, but there are also fees of $7,072.50 and other costs of $523.50, as well as the $1,590 in anticipated fees.
Sure. I'm granting the fee petition as you requested.
Okay. Okay, great. Thank you, Your Honor.
And it was very costly and $501.60. The motion to seal is granted. Two things. We had a motion to seal, and Your Honor granted it in part, I believe, pending the filing of the additional declarations. So I would appreciate it if the that order would extend to the declarations that were filed subsequently conditionally under seal. Those are all sealed? I'm sorry? Those are sealed? Yes. Okay. Mr. Weitzman's and Mr. Modopper's. I'm ordering that those are sealed. Oh, thank you, Your Honor. And one more thing, Your Honor, we have an OSC next week for the accounting. We are working on it. I have a draft. In addition to the pandemic, however, the person responsible for doing the accounting, the accountant actually, surprisingly, or not surprisingly, had a baby in the middle of all of this. So she's on maternity leave, but she is still working on it. So I'm thinking that maybe we need another 30 days. Is that possible? The date exactly that your OSC filing is set for in here? I think it's the 30th. It's on the 30th or 31st. Okay, it's on the 31st, and I will advance that OSC rate filing of the accounting from July 31st, and why don't I reset it for August 28th at 9:30. Okay, that's great. Thank you, Your Honor. Okay. Anything else, Ms. Cohen? Nothing for me, Your Honor.
No, I have nothing else, Your Honor.
Okay. Anything for Prince?
No, Your Honor. I appreciate it.
Okay. Anything for Paris?
No, Your Honor.
Thank you. Anything for Catherine Jackson?
No, Your Honor.
Thank you for your patience this morning. Appreciate it.
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
Thanks, Your Honor. Bye.
Bye. Bye.
Let me try number 12 again, which is Fishman. Do I have Ms. Niemet?
You do, Your Honor.
Thank you, Mr.
Howard Camp also on a link, so to speak.
I couldn't understand you. Is that Mr. Kapp?
Yes, this is Mr. Camp. I've doubled up on this MENAP's telephone call in, so we're trying to do our best.
Okay. And that was clear. I think if you're close to the handset or whatever it is, that will be best. And then do I have Ms. Benedict?
Yes, Your Honor. Thank you.
Thank you. And do I have Ms. D. Petritonio?
Yes, Your Honor.
Thank you very much. So let me ask Ms. Benedict when it is that you think the director is actually going to be able to complete the, I've read the papers, Mr. Kapp. When do you think that the director can complete the Topanga analysis?
We're hopeful that he can complete it in in 90 days, Your Honor. That's our hope.
I think that's too long. If I had ordered a writ based on the petition and ordered the director to comply with Topanga, I probably wouldn't even have given to July, but I did. So I'm not sure why I shouldn't order the director to comply with my order. I want to say 30 days. I mean, it has been since January.
I understand, Your Honor. You know, I can only say that we've been at the DIR have been dealing with COVID since February. Could I ask for 60, just because, again, the situation is so fluid, and the director is, this is important, but he has many important things. And I'm not trying to make light of the situation, but we have many, many pressing things here, and the director does as well. Could we get 60? And I will impress upon him the situation.
Well, I'm ordering the director to complete the Topanga analysis by August 28th. That's 5 weeks. And it's just going to have to be a priority. So August 28th, and then I think I should bring you back here on September 11th for argument. Ms. Benedict, would those dates work for you, September 11th at 9:30?
That'd be fine.
I couldn't understand you, I'm sorry.
Your Honor, me? Oh, sorry.
Okay, let me hear from Ms. Benedict. Can you appear on September 11th to argue the director's Topanga decision on that's due on August 28th?
That'd be fine, Your Honor. Thank you so much.
Okay, Mr. Kapp, can you do that date?
I can do the date, Your Honor, but that leaves us less than 2 weeks. And presumably they're going to want to have some time to brief whatever is in there. So, I mean, you're talking about my having to block out the entire week and without knowing what's going to happen. And I do have some other things, but I'll be happy to push off what I can. And by the way, September 7th is Labor Day, so I'm going to lose that day. So I would ask that it be done faster. Let's take September 11th. But really, there's no point for 5 weeks or 4 weeks. Just give us more time to respond.
Sure. The agreement was we would come in and argue without additional briefing.
Well, I have no idea what he's going to say. Literally zero.
Okay. So if you want to continue it beyond that date, then why don't we see what the director says? And if you need to continue it, you can continue it.
All right. Okay. If it gets it done earlier, maybe this will be a moot issue. But September 11th will be there.
Okay. I am ordering the director to comply with my order by August 28th. A written decision distributed to the parties by August 28th. I'm then ordering that on September 11th at 9:30 a.m. we will argue based on the new information we have from the director. If anybody wants a continuance because of the way the director handled the matter, then you can move for a continuance. But I agree with Mr. Kapp. It's time to move this along, and I think 2 weeks is plenty of time to review the director's decision. You know exactly what the issue is.
Your Honor, my apologies. Oh, Your Honor, all I was going to say, this is Mona Niemat, all I was going to say is that as the course of conduct has been, Dr. Fishman's side will accept service by email on that day or before.
All right. Mr. Kapp, will you give notice?
Sure.
All right. Ms. Benedict, anything further?
Your Honor, we just wanted to know about the administrative records, the unopposed.
Thank you very much. Yes, thank you very much. That's granted. I apologize. The motion to augment is granted.
Okay, well, wonderful, Your Honor. Thank you so much.
Thank you very much. Take care, everyone.
You too. Thank you.
Thank you.
East Drive, App Road, distribution again. Mr. Covington, are you there?
I am, Your Honor. I've read your tentative.
Okay, and do I have a defendant?
Yes, good morning, Your Honor, and Grassel for tentative, and I've read your tentative as well.
Thank you very much. Would you like to be heard on the tentative?
2 issues briefly.
Yes.
For starters, the pricing violations go against plaintiff's likelihood of success of merits. It wasn't necessarily to request an offset, but after reviewing your tentative, it looks like there were evidentiary issues that I wouldn't really be able to argue. So I think there would be the same result. And then defendants also would like to file a motion to substitute undertaking for the writ of attachment under CCP 489.310. And so I'm not sure if we could get extra time before the writ of attachment is issued so that we could bring that motion.
The bond you're willing to post.
Pardon?
What is the amount of the undertaking you're willing to post?
I think I have to double check with my client, but I think they would like to counter the entire writ of attachment with an undertaking.
Your position on that, if the amount of the attachment, I forget it was $1,023,000, if there was an undertaking posted in that amount, do you have an objection, Mr. Covington? I lost Mr. Covington.
Your Honor, this is Mr. Covington. I didn't hear much of what you just said.
Okay.
And I heard only part of what Mr. Grassel said.
Okay, Mr. Grassel said his client would like to post an undertaking instead of the attachment, and I asked what the amount of the undertaking would be, and he suggested the entire amount of the attachment, and I'm wondering what your position is on that. If I extended the TPO for some period of time for the undertaking to be posted in the entire amount of the attachment, what's your thought about that?
Yeah, I haven't had any time to think about it. And he's considering bonding around the attachment under, what, 489.310? Yeah.
Do you want me to come back to you?
Yeah, why don't you give me a few minutes to think about it?
Okay,
Yes. Thank you.
If we can get it resolved today, or I can make an order extending the TPO, and we can figure out how to make that work, then you won't have to go through this rigmarole to try to be heard again.
That's true, Your Honor. We had planned to probably attach, other properties as well that were, not subject to the TPO. There's a real risk that Mr. Verschinnen will try to transfer or encumber his other assets, which would also be subject to an attachment. And we may need to proceed against those because we're not sure there's enough equity in the gas stations. So I'm not sure the TPO helps us because it doesn't prevent Mr. Verschinnen from encumbering his other properties. So it's one concern about just moving forward with the limited TPO that was granted previously. But please pass this for just a minute and let me just think about this. Thank you.
And if you guys want to go offline and chat, you can do that too. I'll be here. Trust me. I won't go anywhere. I'll still be trying to get
Okay.
All right. Thank you very much.
Thank you.
Thank you.
We'll come back to you. Let's go to number 10, United Homeowners. Who do I have on the line for petitioner? Do I have anyone on the line? Anyone on the line for United Homeowners?
Yes, Your Honor. Kimberly Lewis is here on behalf of
Real Party in Interest, Bedford Investments and Peak Capital.
And Elliot Thompson as well for Bedford and Peak. Thank you, Your Honor.
Thank you very much.
Good morning, Your Honor. This is Kiva Bridge-Muir on behalf of County of Los Angeles and Los Angeles County Board of Supervisors.
Thank you. Elliot Thompson. Do I have anybody for petitioner?
There.
Is it Ms. Grossman Palmer?
She's right there.
She's probably having trouble.
Your Honor, this is Kimberly Lewis for Real Party. I can see Ms. Palmer, the counsel for the petitioner, on my screen, but I can't hear her.
Okay. And Ms. Grossman Palmer is also on Fix the City, which was the other case that I couldn't reach anyone on.
She's holding something up to the screen that says, "Will call back in," I think.
Oh, great.
We'll dial in.
Okay.
We'll dial in.
Thank you. I'll wait. Ms. Grossman Palmer, were you successful? Or must you communicate by cue card? I see her on the screen. Ms. Grossman Palmer?
Yes, Your Honor. I think my line has been unmuted. If you could hold 1 second while I turn the volume on my computer down, that would be helpful. Thank you. Okay, thank you, Your Honor.
Okay, so I've got the county, I've got Real Parties, and now I have Ms. Grossman Palmer on behalf of the petitioner. Ms. Grossman Palmer, would you like to be heard on the tentative?
Yes, Your Honor. I agree with much of the court's analysis in the tentative that petitioners are a prevailing party and that petitioners' rates are reasonable. I won't really get into the reductions on the hours, but I do want to address the issue of reduction based on limited success and specifically the reliance on the source case. In that case, it's a little unclear what relief the petitioner achieved. That case involved, the case says that the petitioner raised challenges not only with CEQA but also to the approval of the project on the basis of a violation of a number of local zoning ordinances. And it's not clear from that case whether an EIR was even required to be prepared as a result of the writ being issued. It simply said that the MND and CUP were vacated and they were ordered to comply with CEQA in approving the project in the future. So the analysis is whether the relief is limited in comparison to the scope of the litigation as a whole. And so I don't think based on the source case that a 40% reduction is justified here. There were, I mean, as the court is aware, of course, any litigation involves lots of non-issue specific activities. So it's not really proper to do a mathematical, you've won on one issue, but you raised 4 issues. As to the contention that we abandoned one challenge on greenhouse gases, we also did not spend any time on that challenge to abandon it, so it didn't really result in any increase in the fees. As to land use, I would take issue with the statement that we provided no legal authority. The court didn't agree that the court had said that we did not show the zoning ordinance that we raised as a basis for land use inconsistency to have been enacted for the protection of environmental conditions, or to protect, as a protective ordinance, I'll say. But that does not mean that we provided no legal authority. So I would say that a reduction of 40% is far too significant in light of the fact that petitioners achieved their litigation objectives, and an environmental impact report is being required to be prepared that will comply with CEQA and contain analysis of all the project alternatives, which is a key thing that that United Homeowners was seeking to achieve. It's like an actual reasoned analysis of projects that may lessen the impact of the proposed project. So I will leave it at that, that I would urge the court to revisit that size of that reduction in light of the source case, its different facts, and the petitioner achieving the relief that it sought out to achieve.
Thank you very much. On behalf of Real Party.
Yes, Your Honor, this is Kimberly Lewis, and thank you for your tentative. First, I'm going to respond to just a couple of things that were in the tentative, and then I'll address the arguments that Ms. Palmer just advanced. First, Your Honor, at page 3 of your tentative, you indicated that you were hoping that we weren't suggesting that the county was not going to undertake a meaningful CEQA review, and that is certainly not what the argument that we were advancing in that section of our brief. The point that I was trying to make is that in reviewing the cases, this case seemed remarkably similar to the La Habra case, and so that in which the case denied attorney's fees completely, and the issue in that case was a citizens group trying to stop a Costco, and the court found that there was just limited relief, and even though an ER was ultimately prepared. But I don't want to spend a lot of time on that, but no, we were not trying to suggest that there will not be a meaningful review. The county will do what they need to do. The second point that I wanted to make was regarding the reduction on the attorney's fees motion, and your court correctly noted that the initial amount requested was too high and reduced it accordingly. And I wanted to point out to the court's attention that in the declaration that Ms. Palmer submitted to justify the $21,000 that they are now seeking, or $22,000, she indicated at paragraph 4 of her reply declaration that this was time we spent preparing this reply brief and an opposition to a motion to tax costs. That's how she says she got to the 22 hours. There was no motion to tax costs in this case. So to the extent that she has the 22 hours, that number is on its face inaccurate and must be further reduced. The last point that I want to make is our reliance on the limited success rule is certainly not limited to just the source case. There are legions of cases pointing out that when a party achieves only limited success, the fees must be reduced accordingly. And those cases start with the U.S. Supreme Court and go all the way down to the Second Circuit. And many of them have been cited in the brief. In fact, I will point out that in many of the cases that petitioners themselves relied on, such as Riverwatch versus County of San Diego, 175 Cal Up 4768, the court reduced the fees there by 50% because they only had a limited success. Even in cases Agora Canal, Agora Cornell Knoll, in which the petitioner had an excellent result, one could say, because they knocked it out on several different cases. It still reduced the fees. So Your Honor is on strong ground in reducing the fees in this matter based on the reasons given. And we would assert that a further reduction is warranted given the fact that the ruling, it stands now, it's judgment. They showed up at the trial. They had a laundry list of claims. Most of them were not pursued. We can identify the billable hours spent on land use, and the court's ruling was they provided no cites to the administrative record, no supporting authority, and so we would urge the court that a further downward revision is warranted.
Let me just say, on that attorney fee petition, I found the appropriate lodestar was 16 hours at the $6.95 an hour. So I recognize that in the initial motion, there was $22,000 that was requested. In the reply, Ms. Grossman-Palmer indicated that it was an estimate and reduced it further, I think, to a total of 21 hours, and I think I reduced it from there, given the hourly fee that's involved at $6.95, to a lodestar amount of 16 hours times the $6.95. So I did reduce the attorney fee motion. Ms. Grossman-Palmer, would you like to respond to anything since you're the moving party that Ms. Lewis said?
Your Honor, no, I don't think that there is. There is an error in the declaration. There was no motion to tax, and that is evident if you review the billing records. So we did not seek any hours for any motion, any fees, or any motion to tax costs. And I do also just want to make sure that the court realizes there was no motion to tax costs, and so the cost memorandum is, of course, final, and petitioners are deemed to be awarded those costs as well. And so, Your Honor, I don't have any specific responses to counsel's arguments there. As I said earlier, I think the 40% is quite high of a reduction in this case, given the results obtained, and I would urge the court to consider a smaller reduction for limited success.
I knew that you did not, I knew that there was no motion to tax filed, because there's that, I put in the footnote about the memo of costs, and that's a ministerial issue for the clerk to enter into the judgment when there's no motion to tax. So I did know that, and to be completely honest, I'm not sure that I saw the language that Ms. Lewis pointed out, but I do know that I looked at and evaluated that attorney fee motion and adjusted the lodestar for that. So let me read the source case and look at the other cases that Ms. Lewis cited, and I will issue an order. All right?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you for your patience. I'll stay on the phone.
Yeah, so I'm going to go back to her other case. Well, I guess she has a couple. Let me just handle number 3, which is Fix the City, which is here for a trial setting conference. Ms. Grossman-Palmer, you represent the petitioner, is that correct?
Yes, Your Honor.
Thank you very much. And I know there's an outstanding notice of related cases, correct?
Do you mean that there is a third related case?
I think that, I know that on one of your cases, I thought it was this case, but it may be the motion to strike case, that there's a pending notice of related case, correct?
Yes, all 3 of those cases raise the same legal issues.
Understood. Okay. So who is representing the city on number 3, Fix the City, which ends in 355, the case number?
Good morning, Your Honor. Donna Wong for the City of Los Angeles on the Fix the City case ending in 355.
Thank you very much. And the party in the Fix the City case ending in 355.
Sorry, Your Honor. I'm with the defendant, the Westwood LLC, Bob Bolbahar.
Are Are you on 355? Case number
Yes,
ending
sir.
355? Okay.
Yes, sir.
Okay. Ms. Grossman Palmer, it's a 1094.5 as well as a 1085. What can you tell me about the record?
Your Honor, this case is likely not going to proceed.